Good morning, good afternoon, or good evening. This is Pamela. Listen, Blake Lively is furious. Furious. Child, we finna find out what's going on with Miss Lively, honey, after this. All right, good evening, good afternoon. Listen, child, the Hollywood Reporter came out with a cover of them talking about the Blake Lively and Justin Baldoni controversy. Here is the report. Here is the cover. The Hollywood Reporter, and this is all owned and uh, functioned by the Hollywood Reporter. I'm just showing you the cover that as it has been thrown across the internet. It says Blake versus Baldoni, an exclusive look behind the battle lines of Hollywood's uncivil war. Now, if you follow my channel, you would have seen that I did a slight dive into how I felt that this case is causing shockwaves through Hollywood, because now it's now we're looking at the fact that how going forward, how does a PR team interact their with their clients, and if the client wants them to bury a story that has something to do with somebody else, would the PR team be willing to do that? Simply because will they or will they not be wanting to do that because of the fact that they're scared to get sued? The other person on the other side of that story will sue them, and that they don't have the protections that we thought, that I would have thought that they had, unless they are PR consultants that work for like big companies like a Sony or a studio or a private business or something like that, where that particular company has enough capital to be able to have protections for their employees. A lot of these PR firms are small businesses. And how will this affect that? But let's get on to why Blake, and if you are interested in that story, let me see. Hold on, people. And if you're interested in that story, y'all, be more. Check out my story here. How Lively versus Baldoni changed the public relations, and will PR firms and entertainers ever trust each other again? Check out that video. And that's where I do like a slight dive on what I think is going on in regards to Hollywood, and how the way PR teams and their clients interact anymore has been forever changed by this lawsuit. But let me share my screen really quick. Now, this story is coming from the New York Post. It's written by Andrew Court. And it says, insulted. Blake Lively blasts, quote, sexist. The Hollywood Reporter's cover lampooning her Justin Baldoni lawsuit, and that they should be ashamed. Now, I showed you a copy. I showed you what that lawsuit looked like. All right. So let's get into sharing this, because I'm not understanding. Let me remove. Let me add the stage. Okay, here we go. Blake Lively isn't amused by the Hollywood Reporter's latest cover. On the February 21st issue, features a cartoon lampooning Lively's lawsuit against her It Ends With Us co-star, Justin Baldoni. The image, designed to look like a retro sci-fi movie poster, shows Lively trying to fire a slingshot with a cell phone at Baldoni from behind, a reference to her legal team trying to subpoena text messages from him. And we will go over the latest letter filed by Justin Baldoni's team in regards to that as well. Uh, She says, according to their team, the framing in this picture is outrageously insulting as it plays into every sexist trope about women who dare to file a workplace complaint, turning them into the aggressor and suggesting that they deserve the retaliation that comes their way. And they are here's a copy of the interesting. He's holding he's got something in his hand as well right here. It looks like a slingshot, but it looks like he has the book in his hand, and she's talking about the text. She's talking about the cell phone information that she wants. So it goes into the history of that, and we won't go into that, but we're very much aware of what the history is in regards to what's going on with this Blake Lively lawsuit. But I just wanted to go over really quick and share this particular tab because this is a letter that was recently filed by Justin Baldoni's lawyer in response to Blake Lively wanting to subpoena cell phones and cell phone records of Justin Baldoni and his team and everybody else. Because you remember, they pretty much have all the information from what's her name, Jennifer Abel, because Stephanie Jones provided them with that information. She said it was within a subpoena, and we haven't figured out who subpoenaed who. And if anybody has figured that out or have found information to that, y'all let me know. So let me so let's read this letter. This was filed on the 24th by Justin Baldoni's attorney, Meester, Siegel, and Fine. It says, Dear Judge Lyman, as counsel for Wayfair Studios, LLC, Justin Baldoni, Jamie Heath, Steve Sarowitz, It Ends With Us Movie, LLC, Melissa Nathan, the agency group, PR, LLC, and Jennifer Abel, collectively the Wayfair parties, and in compliance with the order dated February 19, 2025, we write to advise the court that a dispute remains with respect to subpoenas issued by Blake Lively and Ryan Reynolds, hereon known as the Lively parties, to cellular providers AT&T, Verizon, and T-Mobile, the subpoenas. The parties met and conferred via telephone on February 20th, 2025, concerning the scope of the subpoenas. As a result of that meeting, the Lively parties agreed to withdraw their request in the subpoenas for A, all documents, B, data logs, and C, cell site location information. However, the Lively parties refused to withdraw their request for call and text logs, regardless of whether those logs revealed when, how frequently, and with whom the Wayfair parties, their employees, and various non-parties individuals communicated. For instance, if the cellular provider produced call and text logs of all the phone numbers with whom a Wayfair employee communicated, the Lively parties will be able to use a reverse phone lookup function available online and through private investigators to identify every doctor, medical practitioner, lawyer, relative, friend, and any other persons with whom that employee communicated, regardless of whether such communication was related to the claims or defense herein. Given the Lively party's representation to this court that they merely want to ascertain when and how the defendant and witnesses learned about Ms. Lively's harassment allegations, and whether, when, and with whom the Wayfair parties discredited Ms. Lively through the press and social media, we suggested that the Lively parties limit the subpoena to seek call and text log between specific phone numbers of parties and witnesses. Unfortunately, the Lively rejected that reasonable proposal and have stated that their intention to serve modified subpoenas to the cellular providers that still improperly seek and call tech logs revealing the phone numbers for anyone with whom the wayfarer parties, their employees, and various non-party individuals communicated. And I'm not a lawyer. I don't proclaim to be a lawyer, but that seems to be a stretch. It's subpoenaing, having a subpoena to look at what the parties communicated with each other. That's not an issue. But to look at subpoenas to look at who they talk to, that's outside the scope of that. That's a far reach. That is a far reach, because if it was the other way around, they clearly wouldn't want anything like that going on. So that to me is like a big far reach. But let's continue. Let's continue. And y'all hit that like button. Give me one moment. Let me move some things around. All right. The lively parties have not and cannot explain why they are entitled to ascertain A, the identity of each person with whom the wayfarer parties, their employees, and various non-party individuals have communicated, B, how frequently they communicated, and C, when they communicated. Courts routinely reject such overbroad discovery requests. And then they cite C Crescent City Remodeling LLC versus CRMT Construction and Roofing LLC. The request for every incoming or outgoing text message without regards to parties involved or subject matter content of the message is patently overbroad, as it calls for information that has no conceivable relevance to any claim or defense in this matter. In short, as drafted, plaintiff's subpoena is grossly overbroad, not proportionate to the needs of the case, and amounts to an unabashed fishing expedition. And it keeps going on and keeps going on. Indeed, and I'm not going to read the rest of that because it's just talking about all those different cases and things like that. Indeed, even in a criminal matter, which this case is not, a demand for jail calls and logs extended beyond the bounds of relevance, admissibility, and specificity, and was deemed a fishing expedition prohibited by the federal rules of criminal procedures. And they cite United States versus Rivera. Accordingly, even if narrowed to call and text logs, the subpoenas are still overbroad and on their face. We respectfully reiterate our request that the court squash the subpoena. So they're asking for the courts to squash the subpoena because they're according to what Baldoni's camp is saying, what they're requesting is too broad. If they're requesting for a certain time period, between the time that they started, I guess when the crisis intervention team, or whenever he's got his PR team together, from that time till the end of that time period, which would be like August, September, somewhere in there, and that they were specific as to Melissa Nathan, Jed, Justin Baldoni, what's her name, Stephanie Jones, Wayfair, and all. If they line that specifically to that point in time, that's one thing, and to those particular characters. But just to get to everybody that they talked to, who they said what, all those other things, I think that that's broad. And I know a lot of people say, well, if he doesn't have anything to hide, he should say that. No, it's about, you don't know what people's. It's one thing to be sued for a specific thing. It's another thing for your whole life. We don't want to know, just in the other way, we wouldn't want to know who Blake Lively talked to 2.5 years ago. And because what if it comes up that you pull up some information and it shows that she may have been having an clandestine relationship with somebody. I'm quite sure and I'm not saying that that's true. This is just me just giving an example, because you know how you all like to run with it. Because some of you all are doing way too much for the gram, if you ask me. Sending, from what I understand from the last video that I did, sending inappropriate text messages to both parties. But you wouldn't want all that kind of information there. If you're suing for a certain specific thing, then sue for that certain specific thing. If the text messages and things like that these people sent to for involving a whole nother case, and again, this is why this case is now getting to be outreaching for this whole Hollywood community. Because let's just say for these people who do PR for other people, they're talking about getting all their text messages. They're also talking about going into text messages that they sent to other clients. And I am quite sure that that those other clients are not wanting to have that information put forth. Because think about it. You want all their text messages. What if there's a case going on that another celebrity is dealing with or has dealt with in the past? They're going to have access to that. And I don't think that should be. I don't think that that's appropriate. I would hope that on both sides it should be limited to the time period in which all of this happened, and it should be limited to the people that it happened with. Now that's what I think. Any phone calls or anything like that to people that don't matter and numbers that don't matter, I don't think that they should have that. I think that there are numbers in question. Uh, uh, who did Melissa Nathan talk to in regards to this? Did she talk to the the Hollywood Reporter, TMZ, or whoever? You see what I'm saying? Those types of things, because we're talking about PR. So if they talk to those things like that, but in between there, if they were talking with other clients about or texting other clients and things like that, I don't think that you should have access to that. I don't think that they should have access to that. So I would hope that the judge, I mean, because like I said, getting those cell phone records and all that other stuff, I think it's pertinent to the case. But what's not pertinent is getting the information that these people have on other clients and stuff like that. Or if they talk to their grandmama, if they talk to their wife or somebody like that, in the scope of all those things, I don't think that those things, and I don't think that those people should be fair game. But you tell me what you all think. All right, people, we do this every week. Please like, comment, and subscribe. Please share this video if you care. Y'all, Blake is mad. She is furious because all of this stuff is coming out, and I don't think she wants it, and vice versa. I think Justin Baldoni's life is about to be meticulously picked apart because they're trying to figure out if they can find something against him in the past they could say this is a pattern of behavior. So we will see. We will see, child. Again, please like, comment, and subscribe. Please share this video if you care. What are you all thinking about Blake Lively being furious about the Hollywood Reporter's cover? Y'all let me know down in the comments. All right, people. Please tell a friend, tell a kin, tell a coworker, tell that heifer that you can't stand that I'm over here making these videos. And as always, people, bye-bye.